All right. Good morning. Good morning. We're going to be discussing Article 21, right? We're going to be discussing Article 21 and the related issues that arise out of Article 21 that are going to be important as far as the means is concerned. Now we understand Article 21 has two major components. Okay, Article 21 has two major components. One, the right to life and personal liberty. The right to life and personal liberty. It is out of these two that several issues are going to arise out of. So when we talk about the right to life, we understand that the right to life also includes the right to a dignified life, and it also includes, to a very limited extent, the right to death. And both of these translate into an issue called euthanasia. And dignified life and personal liberty also originate one of India's most talked about issue, which is privacy. And dignified life and personal issues also are the foundation of LGBTQIA plus rights. Okay. Now, we are going to first understand euthanasia, then privacy, and then LGBTQIA. With LGBTQIA and privacy, you must understand that though the primary fundamental right is Article 21, but it also will have certain repercussions to other fundamental rights such as 14, 19, to an extent 25, and so on and so forth. Okay? So let us start with euthanasia. To understand euthanasia, or to understand mercy killing and any of those things, let's first understand how a person dies. There are basically three reasons why a person can die. The first and the more important reason that we look at is, let us say, suicide. Here, the person, on the person's own, willingly wants to end their life, and this is happening in the full consciousness and in a mental capacity. The other extreme to this, the absolute other extreme to this, is murder, where the person is dying involuntarily. The person did not want to die, and the person is dying involuntarily, right? The technical term for murder, as we would know, is called culpable homicide. Culpable means that a blame can be put, and homicide is killing of a human being by another human being. As we know, murder is an absolute criminal offense. Murder is an absolute criminal offense. And somewhere in the midpoint of all of this is euthanasia. In murder, there was absolutely no consent whatsoever of the person who was killed. In suicide, the person gives self-consent and kills the person himself, herself, or themselves. But euthanasia is circumstantial in nature, wherein the medical conditions are such that a person is not able to live a healthy or a dignified life. Okay, so that is something we must understand. Now, we will look at all the three elements and we'll first spend some time on suicide. Okay. Now, let us start. When we look at suicide, we must understand that suicide was originally, and there are two ramifications to this. One is a person is killing themselves completely on their own will. And second, a person is instigated or prompted to kill themselves because somebody else is motivating the person to commit suicide. So this is when the person is being instigated to commit suicide. This in legal terms is also called abetment to suicide. Now, of course, when we look at abetment to suicide, and this is sort of important, when we look at abetment to suicide and the person who is motivating the other person to commit suicide, this of course is criminal. But there has been a lot of development here on whether it is okay to criminalize somebody who is trying to kill themselves without anybody else's influence. Now, there are going to be two outcomes out of this. One, if the suicide is successful, then the person is dead and there is really nothing that can be done. But if the suicide is unsuccessful, the criminal law in our country recognized attempt to suicide as a criminal offense. The criminal law in our country recognized attempt to suicide as a criminal offense. Now, there has been a lot of development on this front, and we're going to look at the broad milestones of that development. Technicalities are not in your syllabus. So, what is suicide? Suicide, in common parlance, in common understanding, is the act of self-murdering or killing oneself. Okay? Now, it is usually an intentional act where the person wants to kill themselves by ending the tragedies or by ending life and circumstances that a person might be facing. Now, in this case, you must understand that suicide is one of the world's darkest and deepest problems. If you look at the World Health Organization reports on suicide, you will understand that almost 8 million people every year die because of suicide. And these numbers have only shot up unimaginably due to the pandemic, right? And as far as India is concerned, more than 2 lakh people in India every year when we look at the National Crime Records Bureau, more than 2 lakh people in India commit suicide. Tamil Nadu and Maharashtra have the highest suicide rates in the country, with approximately 15 to 10% each. Now let us understand what the provision is. The Indian Penal Code under section 309, the Indian Penal Code under section 309 categorically criminalizes attempting suicide and says that a person who tries to commit suicide might be sent to jail for a year or might be imposed with a fine or both. It is in fact ironical, and I think it is hypocritical, that if a person is so upset with the tragedies that the person is going through that has compelled the person to end their life, you are on top of that criminalizing that attempt and sending the person to jail, thereby adding to the tragedies that the person already faces. And this is why there was an urgent need to reform the law of suicide in the country. Right now, there have been, several cases which are common to euthanasia also, such as the Gyan Kaur case, which I will discuss in the state of Punjab, and then of course the Aruna Shambhak case. See, in the Gyan Kaur case, the Gyan Kaur versus State of Punjab case, the Supreme Court took a very conservative view and said, when you're ending your life, it is an unnatural exercise. And the law cannot give you the right to perform an unnatural exercise which ends your life. And therefore, any attempt to end your life unnaturally, whether it is suicide or anything else, which will also include euthanasia, is illegal and is wrong. That is why suicide continued to be criminalized as far as the Gyan Kaur case was concerned. But the Aruna Shambhak case, which is India's foundational case on euthanasia, forced the Supreme Court to change its view on mercy killing, on medical reasons to end somebody's life. The reason was a very simple one, that in the Aruna Shambhak case, a nurse who was working at the Bombay hospital was gang raped and was in a state of absolute coma for years to come, and therefore was not in any state to live their lives comfortably. Now, you must understand that this section 309 is one of the laws that India has retained and has carried over from the British Raj, from the pre-independence era. This is a provision which has been a part of the law even during the British Raj, right? And what is very interesting to note is that the same Britishers who had the Indian Penal Code in 1961 in the UK through the abolition, through the Suicide Act of 1961 in Britain, UK has abolished attempt to suicide, but the same law that UK had as a part of criminal law in India still continues to be carried on as a criminal offence in the country, right? The Law Commission had actually undertaken its review, and the Law Commission had very clearly said that this penal provision, this criminalization of suicide, is harsh, is unjustified, and therefore must urgently be reviewed. And it said that whatever acts of cruelty, whatever compelling reasons, if there is a person who is responsible for creating a situation that is compelling a person to commit suicide, they should be the ones who should really be, held accountable, because they are the ones in one way or the other through suicide are actually committing murder. The legislatures of the country also had a similar view in the 1970s. I think in 1972, a bill was introduced in the Rajya Sabha to decriminalize this and to remove this provision. But it did not pass through the Lok Sabha. But finally, in 2017, through the Mental Health Care Act, there has been a substantial change through this law. So this Mental Health Care Act, which was enacted in 2017 and started to get implemented from 2018 onwards, this act has significantly watered down or reduced the impact of Section 309 of the Indian Penal Code. Okay? So what basically happens is that it has sort of diluted 309, made it inoperative, made it almost non-existent by a specific provision in the Mental Health Care Act. Right? It is still a part of the Indian Penal Code, but the provisions of the Mental Health Care Act will override the provisions of the Indian Penal Code, Section 309. Section 309 continues to still very much be a part of the Indian Penal Code, but now it is overridden by a new specific provision under the Mental Health Care Act. Okay? It very clearly says that, and the provision is, irrespective of anything which is written in Section 309, any person who tries to commit suicide shall be presumed, unless otherwise, to have severe stress and will not be tried and punished under the Indian Penal Code. Unless there is a specific way that you can prove that this was not a stress or a tragedy related suicide, you will not apply the Indian Penal Code here. So, not only this, the Mental Health Care Act also says that if somebody tries to commit suicide and is therefore unsuccessful, then the person shall not be treated like a criminal. Instead, the state shall extend mental health support to this person, and try to make their lives better. And this is why there has been, of course, a debate and revolution on suicide. Okay? But abatement to suicide, as I was telling you about, is still very much a criminal offense. Okay? Now, students of the law optional should get into deeper details of this, the constituents of criminal law and the implications of this on medical legal cases. But students of polity for general studies, this is more than enough. You don't need anything else beyond this as far as your entire UPSC syllabus is concerned. The law optional students may have to get into a lot more, details into this. Okay? Which basically means that, like for example, in law we understand that if attempt to suicide tomorrow, like attempt to suicide is no longer a crime, then does it also have to be a medical legal case? Because if it's a medical legal case, then medical practitioners have to make sure that there is law enforcement as far as the treatment of the patient is concerned. So there are some complications there. For students of the law optional, this is a very exciting piece of legislation to get into. But for ordinary GS students like you, for most of you, you don't have to worry about it. Now let us spend some time on euthanasia in terms of the extension to life and liberty. Euthanasia, as I said, primarily functions on that a life must be dignified, must be worth living, and if it is not dignified and worth living, then there could be a reason to to end life. Now, what is euthanasia? Euthanasia, in an extremely simple piece of words, in a simple piece of sentence, is the practice of intentionally ending one's life. It is the practice of intentionally ending one's life, not for any unknown reason, but the intention is to relieve pain and suffering. That intention behind ending one's life is to relieve pain and suffering. The word euthanasia has Greek origins and Greek roots, and it literally translates into good death. It literally translates into good deaths. Okay? Do we understand this? Are we clear? All right. Sorry. So, good death, easy death, mercy killing, these are all alternative names, synonyms to euthanasia as we would know it, right? It is generally associated with people who have certain terminal illnesses. Terminal illnesses means that the disease that you have is most likely going to cause death. For example, cancer, or any of those immunological diseases, or so much, right? Yes, Saurav, I will immediately get into this. Okay, now you must understand that this right to die, or this right to end one's life because of medical reasons, is not something which is a very modern idea. It's not something which is a part of modern society. In fact, it has been in discussions across civilizations for a very, very long time. Okay? So now let's understand this. Let's understand this from a simple perspective. Euthanasia is going to have two layers, or two dimensions, or two perspectives. The first perspective is from the view of the patient. The first perspective is based on consent, because the differentiating factor here is consent, consent, and consent. So, with respect to consent, there are going to be two forms of euthanasia as general understandings. One, when the patient themselves are requesting it. The patient themselves are requesting it. And second, the patient is in such a condition of health that the patient is unable to request it. In such a scenario, representatives of the patient, the family or the relatives, are going to request for euthanasia. Now, as far as the Indian law is concerned, this is not allowed. The patient can't request on their own, whereas in a situation where the patient is unable to request consent, the family members and relatives can. And this is the difference between a vegetative state and a non-vegetative state. For example, if a person is in coma, they can't process, they can't explain, they can't tell you what is happening, then the family members can. But if the patient has undergone a severe accident, which may have led to, the amputation of a few organs or a few limbs, in that case, the patient can request it, but that is not legally allowed as of now. And there has been some Supreme Court development on this, and we will talk about this in the context of a living will in just some time. So this is the basic term. This is how the law on euthanasia in India is. Then comes the second perspective. The second perspective is, now that we figured out that, okay, it is the patient consent, now the second perspective or the second dimension is the method. How are you going to execute death to the patient? How are you going to execute death to the patient? Now here, there are two ways. One is the doctor administers a lethal injection which leads to the death of the patient, or the doctor withdraws medical support or life support. In India, this is decided on a case-to-case basis, and mostly withdrawal of medical life support is a preferred form of execution. But there is no standard law on method. You must also understand that the law that we're talking about here is a law of privilege. Because euthanasia, as much as it is a legal issue, it also has severe ethical implications. For example, think of the hundreds of people in this country, thousands of people actually, who would have died because of COVID because they were not able to afford hospital treatment in their lives. Now, isn't that euthanasia? Isn't that some form of euthanasia? Or is it murder? Or is it suicide? So there are so many ethical implications here. If there is a poor person who can't afford medicines, because of which the person is dying, which means you're withdrawing some form of medical support, what do you do then? So the law that we're here talking about is an entitled law, is a law which basically gives you an entire ecosystem, right? So this is broadly what the law is. Now we will get into the analysis of the law. You can take 1 minute and note this down in your notebooks. I'll just clear up my throat and come. All right. Now that we've understood this, this is your first slide. Now that we've understood this, let's get into the other discussions of this. Let's get into the morality of this. Okay? Now, there are several related terms that are used with respect to euthanasia. There are several related terms which are used with respect to euthanasia. We'll get to those terms. There are certain associated terms. They're not necessarily the same thing as euthanasia, but there are certain related terms. For example, there is a term called assisted dying or assisted suicide. Assisted dying. Now please understand this means. This basically means physician-induced suicide. This means physician-induced suicide, and it also means active voluntary euthanasia. So this is voluntary, this is involuntary, this is active, and this is passive. So patient requesting it is voluntary. Family members are requesting it on the behalf of the patient is involuntary from the patient's perspective. Administering lethal injections is active, and withdrawing life support is passive. So assisted dying is comprised of two things. First, the doctor assisting the process, and this also includes voluntary active euthanasia. The patient requested it, the patient requested it, and the patient requested it, and the doctor administered the patient with a lethal injection up the morphine to ensure that the patient is dying properly. So, this is a form of voluntary and active euthanasia. This is one of the related terms to euthanasia. The second term related to euthanasia is palliative care. This is something that I will also teach you in the healthcare sector of governance. Now, palliative care is basically, in very simple terms, called end of life care. It is called end of life care. Palliative care is also called end of life care. Now, what is meant by end of life care? This basically means we are referring to those patients who are undergoing treatment for terminal diseases, that it is only a matter of time. Here, you are not fastening the process of death. You are not hastening the process of death. None of that is happening. What you are basically doing is that till the time the patients are alive, you are giving them all possible medical support and care so that their transition into after death is smooth, painless as possible. That's palliative care. Like, for example, therapy or treatment to counter the ill effects of chemotherapy, which cancer patients often undergo, is essentially an example of palliative care. Then this is something which is very common in Europe and in the West. There is something called DNR. Do not resuscitate. Okay. Do not resuscitate. Or DNR. DNR or do not resuscitate means that if a patient has signed a DNR form or has issued a DNR, then the doctor cannot perform any treatment on the patient. The doctor cannot perform any treatment on the patient. Okay. Now you must understand this. What does this mean? This means any treatment if the patient is sinking. How does a patient usually sink? When the heart stops. When the heart stops is when the patient usually sinks, right? In such a scenario, the doctor will not do anything to revive the patient. The doctor will not do anything to resuscitate the patient. Okay, so this is very important. Now you must understand, they are, sometimes controversial. They are sometimes sort of in the gray area, because a lot of times, they can get abused by the families or by the relatives and so on and so forth. They're essentially intended to, prevent patients from the after effects. What happens a lot of times is that sometimes when you're resuscitating the patient so hard, you're providing, a chest revival, कि तुमने हड्डी ही तोड़ दी, रिब ही तोड़ दी. So that is why sometimes, DNR orders are issued. Like a lot of times during the recovery of the heart or during, reviving of a sinking heart, because blood flow gets restricted, and blood flow, when it gets restricted to the brain, can often sometimes cause brain damage, right? So a lot of times what happens is, a lot of people do not want invasive heart surgeries, because they can cause brain damage in case there is any blood loss to the brain. So a lot of times people sign DNR orders accordingly. So that is what is called a DNR. Do not resuscitate. Okay. Now, this is broadly some of the related terms. Now we must understand. Yes. Akash, I may have written it wrongly, the spelling here, and thank you for pointing it out. But let me tell you, I can understand the spelling. It is Resuscitate, Resuscitate. I understand that. Sorry for making such a colossal error on the spelling. Okay, I will keep that in mind. A fault of the tongue is no fault of the mind, but one who remarks is very unkind. Anyways, so let's continue with this. As long as you understood what I'm talking about, it is fine. Right? Now, let's continue. Once we understand this, there are certain primary arguments which are for and against euthanasia. You will also use these arguments in your ethics answers, because this is a socio-legal, ethical, moral debate. So let's understand this. First, for example, the primary argument for euthanasia is that it is based on empathy and morality. That why would you let a person suffer in pain for your own selfish need? You want the person to be alive, but the person is not in a space to be alive, is not leading a life worth leading. So a true form of empathy and a true form of morality will always be with respect to favoring euthanasia. Okay? Second, the right to die peacefully. The right to die peacefully could also be construed as a fundamental right under Article 21. If you have the right to life, then you should also have the right to die peacefully. Third, I should get to decide what I would want with me in case I am unwell. It fundamentally compromises what is called human autonomy, or the right to human self-determination. And as a result, you are not able to have absolute control over the choice of what should be done to you or not. And fourthly, death is a private matter, and there should not be any state intervention in the private matter whatsoever, right? So these are some primary arguments favoring euthanasia. Then there are primary arguments against euthanasia also. And the arguments are actually quite fairly exhaustive. You see, firstly, the distinction between withdrawing life support and injecting somebody with a lethal injection, that difference is morally very, very ठीक है नहीं Shashi, there is no. Akash was genuinely being very nice. He was genuinely informing us it was a mistake. I was just pulling Akash's leg because I shared that camaraderie with Akash as he's a fellow video gamer. So Shashi, don't add fuel when there is no fire. Anyways, so the difference between withdrawing life support and the difference between injecting a patient with a lethal injection is morally very significant. Morally very significant. For example, you're driving straight on the road and somebody comes in front of your car, and you purposely turn the steering of the car to run somebody over that you found on the road who you don't like. That distinction is extremely significant. And that is the distinction between Bhaijan and, a lot of other people. But in the case of Bhaijan, as we know, the driver was driving, not Bhaijan was driving. So there is a moral distinction as far as, the execution is concerned of euthanasia, right? Secondly, if everybody could so easily and so seamlessly get to, withdraw life, at a moral level, it could reduce the general value of life, that society would have. The general value of life that society would have, right? Third, if medical science was so foolproof, then why would there be developments in medical science that could not be proven, that could not be justified? That is why a lot of times we often hear of things like miracles. We often hear a lot of times things like medical miracles, that people have woken up after a coma after 10 years, 20 years, and all of those things happen. So that is also a scope. That is also an implication. So let's not forget that. I mean, you cannot ever be 100% sure that this person is never going to wake up. There is no 100% surety of this. So doctors or medical professionals can't pray God on that front. Fourth, you must also understand that when euthanasia can be easily available as a recourse for terminally ill patients, the research on finding cure for terminally ill patients can be significantly impacted, because research and funding and the patients are a vicious cycle. If there are not going to be enough patients who are fighting cancer, why would pharmaceutical companies would look at basic reasons for extending research on cancer? So that's something which is true. Then you've got the fifth point. The fifth point is extremely clear on this. The fifth point is, boss, why are you assuming that there is pain in death? That is why you have palliative care, to make sure that you have a pain-free transition into death. So don't assume that all deaths are painful. Don't assume that all deaths are painful. All deaths, as a matter of fact, don't necessarily have to be painful, right? That's a fifth point. And then sixth, and you must understand this, that there is absolutely no foolproof way about this. Sometimes, relatives for property reasons can abuse the process. Relatives for financial reasons can abuse the process. And seventh, and the last point is, this is an irreversible decision. It's not as if you can, start all over again. This is a question of life and death. Okay. And several countries in the world, for example, Netherlands, Belgium, Canada, Australia, they have legalized euthanasia. And several countries such as Switzerland, Netherlands, again Belgium, Canada, Australia, some states of the US have also legalized assisted suicide. So there is in fact a fair enough legislative support internationally for this matter, right? Now, as far as India is concerned, as far as our laws on euthanasia is concerned, I'll give you a basic sort of evolution on the law. And very interestingly, the discourse on euthanasia is primarily driven by Supreme Court judgments with a few High Court judgments here or there. It is very interesting to note that our beloved Parliament has played a negligible role in formulating any guidelines or a policy or a law. It is a subject matter which has been completely ignored as far as the importance and the relevance that it should have been given by the Honorable Parliament in India. Right? Now, one of the first ever cases with respect to euthanasia was in 1986. Again, for UPSC, you don't have to remember this case. I am just explaining this case to explain to you the context. Okay? This case is called the Maruti Dubbal versus State of Maharashtra case. The Maruti Dubbal versus State of Maharashtra case. Okay? State of Maharashtra. Now, in Maruti Dubbal versus State of Maharashtra, you must understand, the Supreme Court had taken a very liberal view on euthanasia. The Supreme Court said that the right to life, in fact, this was the Supreme Court, it went to the Supreme Court reference later, but this was primarily a Bombay High Court case. The Bombay High Court had originally discussed and said that the right to life could also be interpreted as the right to not live a forced life. So the right to life here should also mean that the right to life it also includes the right to not live a forced life. To not live a forced life. Then in 1994, in the Ratinam versus Union of India case, this is in 1994, this is a Supreme Court case, P. Ratinam versus Union of India. Law optional students should know most of these cases, but GS, again, polity students, you don't need to know this. In 1994, Ratina versus Union of India, you don't have to memorize this. You must understand the Supreme Court held that, in fact, it basically, in Ratinam's case, it held Section 309 as unconstitutional. It rendered Section 309 as unconstitutional, which was basically attempt to suicide, right? This was overruled. And all of this in 1996, as I was telling you, in the Gyan Kaur versus Union of India case, where the Supreme Court clearly and categorically declared, this is Gyan Kaur versus Punjab, my bad, versus State of Punjab, where the Supreme Court categorically declared that both active and passive euthanasia in any form is illegal. Euthanasia in any form is illegal, right? And you cannot try to execute it. And the right to life did not include the right to die, thereby reversing the impact of Section 309. Finally, in 2011, the Aruna Shambhag case, right? The Aruna Shambhag case, Aruna Shambhag versus Union of India. This is where the Supreme Court allowed for euthanasia. It was a milestone judgment where it said that passive euthanasia means involuntary euthanasia. Here it means involuntary euthanasia will be allowed on a case-by-case basis, where the High Court of the concerned state where the request has come will set up a committee comprising of medical and other experts, and they will decide on the individual merits of the case. Okay, the individual merits of the case. Now, all of this aside, 2019 has been a remarkable year. 2018 has been a remarkable year on this, because this has had an extremely important impact on voluntary euthanasia. It has had an extremely important impact on voluntary euthanasia. How? The Supreme Court delivered a judgment in 2018 by something called Common Cause versus Union of India. You would remember we had used the same name for the sedition case also, which the Supreme Court did not entertain, right? So Common Cause versus Union of India, in which the Supreme Court conceptualized something called living will. So a living will, like a property will or an ancestral will, a living will is basically this, wherein a person in sound mind or body, can draft a will or can have a will drafted specifying any medical treatment or the lack of it in case of a future medical exigency. In case of a future medical exigency, मतलब सिंपल भाषा में कि आज मैं एक बिल लिख सकता हूँ कि कल को अगर मेरा एक्सीडेंट हो जाए and let us say I lose my limbs and lose my arms, please perform euthanasia on me. But I can do it today because I'm in sound mind or body. I have an accident, I lose my limbs, I go to the hospital and I then draft a living will. That is not going to be allowed. This is something which has to be done beforehand, will be registered with the local district authority. They will verify it and then can recommend the course of treatment to the medical establishment. The procedure is not important for you, just the fact that there is going to be a living will which partially allows for voluntary euthanasia. Now for UPSC, there are only two judgments, the 2011 judgment and the 2018 judgment. These are the only two judgments that you need to know, the only two judgments that you need to remember. Everything else is not to be done as far as your civil services is concerned. Okay? Now, apart from this, of course, the Law Commission in its 2006 report, even the Medical Council, and in fact the Rajagopal Committee, all of them have recommended that we must have some form of, legality and some form of structure to euthanasia. In fact, if I give you some suggestions as way forward, I'll give you some technical suggestions as way forward, and I'll give you some general suggestions which could be used in your conclusion also. So for example, in 2006, in its 196th report of the Law Commission of India, they recommended that the Parliament must enact a law on euthanasia, which of course the Parliament has not. And it also said that there must be some law to protect terminally ill patients who refuse nutrition or any medical treatment and so on and so forth. DNR is at that time before you get into a procedure. Living will is way before. That's the first way forward. The second way forward here would be that the Medical Council of India recommended that the Medical Council of India, which is now going to be the National Medical Commission, should also issue very clear guidelines on the matter, which they of course have not. And third, Rajagopal committee has also said that there must be some, you know, this is 2018, post the living will judgment, that there must be some clarity of the terms. They said passive euthanasia is a very misleading term. It has a negative connotation to it. So instead of passive euthanasia having a negative term, it should be called withholding or stopping future treatment, so that people understand what the matter is. With, of course, there should be a doctor's panel, and therefore, as and when needed, living will could be executed. There should be a district-wise doctor panel for living will. Panel of doctors. Now, these are some specific suggestions, and the general concluding remarks are that you must understand many countries have sophisticated regimes, proper compliance of medical procedures. India is in a very nuanced shape given the lack of regulatory ecosystems as far as medical science and medical care is concerned. And the very scope of transformation of mercy killing into selfish gains, all of those things must be induced by proper laws. And the only solution to this is that the parliament must give guidelines. By the way, you can use this judgment, the Aruna Shambhag judgment, as a fantastic example of judicial legislation / judicial activism, because you're reviewing something that doesn't exist. So now do you understand how examples are actually recycled from within the constitution itself? Examples are actually recycled from within the constitution, judgments from within the constitution itself. Okay? Yes, Vaibhav. The clarity has not been issued yet, so let's hope that is mostly the case. Now you can take a 5-minute break, and then we'll move to privacy and LGBTQ, which are actually quite simple topics. ठीक है, चलिए. All right. Let's continue with privacy. Okay, Basim, I'll have a look. Rajgopal committee said there should be a district-wise doctor panel. Okay. Conte, that is the same one. I have got your emails. I'll get back to you. Arshad, it's basically that now passive euthanasia is allowed. Abhishek, moral distinction is how you administer it has a significant moral repercussion. Okay? Right. Now, privacy. When we discuss privacy, we must first understand the ramifications of privacy and the players in privacy, right? Let's first understand the ramifications of privacy. At the outset, I must tell you that there is no universally accepted definition of privacy. There absolutely is not. But privacy is generally considered to be an idea wherein you are able to identify, you are able to secure certain personal information, personal identifications, personal traits as your own. Okay. 196 Commission recommended that a law should be made. Anyway. So, the first thing that we understand is there is no universal definition of privacy. There is no universal definition of privacy. There is no legally accepted definition even in India today. What has basically happened is that in 2017, the Supreme Court in the Puttu Swami case, Puttu Swami versus Union of India, retired judge, Justice Puttu Swami versus Union of India, has basically said privacy is an implied fundamental right under Article 21 and also has ramifications to 19, 14, etc., etc. But primarily is an implied fundamental right under 21. So if in the prelims you get a question, right to privacy is a fundamental right under what? You will always choose Article 21. I've always told you this before. Default is always Article 21. Right? Now, this judgment has basically opened the doors and is going to be a catalyst to a lot of other issues that exist in India today which affect privacy, right? Of course, the most commonly understood issue with privacy is data / internet. The most commonly understood implication of privacy is data / internet. Then, of course, there is a very direct implication of privacy on gender. I'll explain this to you. Then you also have issues on expression, issues on orientation, issues with respect to identification, right? A very important consequence of privacy, right? And apart from that, there is also an implication of privacy on law and order, right? Now, let me give you some implications of privacy. For example, when we look at data and internet, we are primarily concerned with the IT rules of 2021, which we had discussed in Article 19 also, where there are basically two fundamental issues. One is that data companies, intermediaries, or let us say they're called social intermediaries, like a WhatsApp, a Twitter, a Facebook, an Instagram, all of those, they have to disclose the originator's identity in case it is an objectionable message which could have potentially caused a riot. मतलब एक सीधी बात है कि we have made IT rules in such a way that if there is a WhatsApp message which has been made viral across thousands and thousands of WhatsApp groups and thousands of WhatsApp users, and that message has caused people to riot. Suppose it was a video of lynching or anything, and that has caused people to go riot, then the government can ask WhatsApp to disclose who sent the message, what number was the message sent from, where was it sent from, when was it sent from, and so on and so forth. So there is an originator identity disclosure issue with respect to your IT rules. That is the first issue with respect to IT rules. The second issue, which has therefore become a little more important in the context of our discussion today, also pertains to the IT rules in the sense that there has been some form of self-regulation, right? We've discussed this. Now, self-regulation does not particularly pertain to privacy, but it originates from the IT rules. The originator identity issue is what actually originates and has relating to privacy, right? So that is that. Now, of course, this is your data issue, your internet issue. This judgment could also then have a significant impact on gender issues, such as marital rape, which has also been discussed heavily in the news nowadays. The fact that in India, marital rape is only criminal in the case of a child marriage at the option of the minor is something which needs to be looked at, which is basically a debate today, because at the end of the day, somebody is forcefully being intimate with a person, and that is violating the bodily privacy of the person, the physical privacy of the person. So that is what. Similarly, when we have restricted the rights of women with respect to abortion and have said under ordinary cases only 4 weeks of time is permitted where a person can get the fetus aborted, is something which can be looked into now, given the fact that privacy is a fundamental right. Third is the issue of surrogacy. Where we have banned what is called commercial surrogacy. Surrogacy is basically renting a womb and the baby would be given to the person that you wanted to intend it to. In India, commercial surrogacy is illegal. Only altruistic surrogacy is going to be legal, which means you can only do it to help somebody who really wants a child. So, a distant relative or somebody close to you. But you cannot do this as a method of a financial transaction. That somebody comes, fertilizes, and therefore, the baby is delivered and the baby is taken by the people who've paid for you, right? So that's commercial surrogacy. That is not allowed. In fact, very recently, a very heartwarming movie was also made on surrogacy in recent times. So there is no doubt in a very interesting application of privacy on gender. There are some examples that I've given you. Then, privacy also has a massive impact on the evolution of LGBTQIA rights, if you think about it. Because, for example, who you are, who you like, what gender do you identify as, is something which is your personal identification. There is nothing more private than who you like, what gender do you identify with, and what gender do you want to be. Now, one of the reasons why homosexuality has been decriminalized in India in 2018 because of the Navtej Singh Johar judgment, which I will discuss in some time, is because the Puttu Swami judgment was a catalyst, and the Navtej Singh Johar judgment in 2018 heavily relied on the Puttu Swami judgment about this matter. Okay, so this is basically an identification matrix. Apart from that, privacy could also have a lot of implications on surveillance, can also have an issue on search and seizure, forceful investigations, and so on and so forth. So there are several law and order implications also which arise from privacy. Now, these and so many more issues can now be relooked from the prism that privacy is now what is called a fundamental right. Privacy is what is now called an implied fundamental right as far as India is concerned. Okay, these are the possible implications. Now, in this ecosystem, there are several instances that have happened which have prompted the debate here. Several issues wherein the government, social media companies, big data companies or tech companies, have been the primary stakeholders, apart from, of course, your usual citizens. Now, several instances, like for example, and I'll give you a list of these instances or sort of run you through what is happening in the country on that context, right? So, for example, several instances where Aadhaar has been made compulsory for certain actions. It has been argued it could be a privacy violation. Second, the originator issue that I was telling you about, the originator identification issue, right? The originator identification issue. Third, the Ministry of Home Affairs very recently has authorized 10 central agencies to intercept any form of information, and it was basically giving the power to intercept any form of information recorded on any computer in the country. I know this sounds ridiculous, but this is true. Fourth, in 2018, the Ministry of Information and Broadcasting has proposed the idea of a social monitoring hub, which will basically look into a technical solution to snoop into or to monitor any social media activity, including emails, in case there is a sensitivity here, right? The Income Tax Department is looking at something called a Project Insight, which is going to have certain surveillance tools that will have the Income Tax Department look into certain financial transactions, right? Okay. 6, the Transport Ministry of the country very recently sold vehicular data generating millions of revenue to insurance and other private companies. Impact on privacy. The government is actively considering face recognition technologies to look at interception of crime. And lastly, we discussed the Pegasus issue, wherein there was a degree of surveillance which was being executed in the country. Okay? Now, these are some of the instances where the government in itself has been put into a question mark. Now, for example, when the person does not get the absolute right to decide when they want to abort the baby or not, when the person does not get the right to decide whether they want to rend their womb or not, and whether the person does not get the full right to consent, even if the person is married or not, it is an issue of privacy. It is an issue of bodily privacy. It is a private matter. It is a person's private matter. Okay, so there are several such instances of government issues. And then we look at social media, or we look at, big tech companies' issues. They also have been in the news very, very recently. For example, WhatsApp, which is a company owned by Facebook, which is now called Meta, came up with a new policy where WhatsApp is going to share the metadata of its users, which means non-personal data of its users, with several businesses which advertise on Facebook. This is argued to be a violation of privacy. The government has asked WhatsApp to withdraw this policy. Right? Twitter has filed a case against the government on the originator identification issue in the Delhi High Court. Right? Interestingly, the birthplace of all of this is Puttu, Swami. And if you don't mind, I'll take 5 minutes of your time to just tell you a little bit about the Puttu Swami case. The Puttu Swami case of 2017 is actually a case on Aadhaar. Okay? And this case primarily looked into the two components of the matter, 1 and 2. The first that it looked into was an amendment that was made to the Aadhaar Act, a law. Was it rightfully passed as a money bill? Was it justified or not? And second, the compulsorization of Aadhaar, to which the Supreme Court largely said that if you're using Aadhaar to give some welfare or benefits to citizens, then you can make it compulsory. For everything else, you can't. But this judgment has been widely misused in terms of Aadhaar. So, for example, you don't need an Aadhaar card technically to open a bank account. You absolutely don't need it. But you need a PAN card to open a bank account. But you need an Aadhaar card to open a PAN card, and all Aadhaar cards need to be linked to their PAN card. So indirectly, you will require an Aadhaar card for a bank account. Okay, so that is a very interesting discussion to have. Anyways, the facts of the Puttu Swami case per se are not particularly relevant for you at the moment because they are not being looked into in a larger detail. Okay, understood this? All right. Okay. Now, if it is okay with you, I'd like to also sort of give you the evolution of the right to privacy, and then we'll get into the technical details of it. The evolution of the right to privacy. Very interesting discussion. You can make a timeline out of this in your answers also, and you will be able to get a lot of clarity on what we are largely trying to say. Okay, so let's understand what the evolution on the right to privacy is. This entire discussion and debate on the right to privacy actually starts from 1948. It actually starts from 1948. Okay. And this is where we are referring to certain constituent assembly debates. I'll give you a brief of each. Don't worry about it, and you can note when I talk to you about it. Then the first case was in 1954, called MP Sharma versus Satish Chandra. MP Sharma versus Satish Chandra. Okay. Then in 1962, a very popular case, Khadak Singh ke Khadak nahi se khadakti hai khidkiyan. This is the origin of that line. Khadak Singh versus the state of Uttar Pradesh. Versus the state of Uttar Pradesh. Then in 1975, I'll tell you the important ones also, don't worry. In 1975, Govind versus the state of Maharashtra. Govind versus the state of, Madhya Pradesh, my bad. Govind versus the state of Madhya Pradesh. Then in 2017, the final case, which is Justice Retired Puttu Swami versus Union of India. I'll walk you through the journey of this so that you understand what it is that we are referring to. Justice Retired or Justice K.S. Puttu Swami versus Union of India. You can take 1 minute to note this down. Then we'll start. I'll just give you a brief idea. As far as UPSC is concerned, 1948, Khadak Singh and Puttu Swami. These are the only three judgments. If you're able to quote these, they're more than enough. Okay. All right. So let's start. The story begins in 1948 in Constituent Assembly debates. And this was the first attempt which was actually made to protect the privacy of an individual against unreasonable state interference. And this was actually debated in our Constituent Assembly, right? Sayyid Karimuddin, who was a member of the Constituent Assembly, had actually moved an amendment to protect the individuals from unreasonable search and seizures on the lines of the American and the Irish Constitution. Where in American and Irish constitutions, there is a dedicated right where citizens cannot be unlawfully searched and their property cannot be unlawfully seized. Dr. B.R. Ambedkar said, we don't need to put this in the constitution because the criminal procedure code is already present and therefore we don't have to worry too much about it. But then of course there was a lot of uproar in the assembly. So Dr. B.R. Ambedkar said, fine, if it is already there in CRPC, then also you can put it in the constitution. They will serve the same purpose whatsoever, right? However, it did not eventually find a place in the text of the constitution. And the matter ended there itself. Then in 1954, in MP Sharma versus Satish Chandra, something very interesting happened. This is a case most people often don't get to hear about, but you may have heard of a group of companies called the Dalmia Group of Companies. This case is about the Dalmia Group of Companies. That is why it's a private party case. So basically what had happened was, this case related to the search and the seizure of certain documents of a few of the companies under the Dalmia Group of Companies, because there were some investigations into the conduct of these companies. It was alleged that these companies were not really bankrupt, but they had declared bankruptcy so that they could avoid paying the debt of its creditors, right? Some FIRs were filed against the companies for cheat and for fraud, and therefore the district magistrate of the concerned area issued certain warrants, issued certain seizure memos and all of that, and subsequently the search and seizures were conducted. Now, obviously, the Dalmia Group of Companies and the persons went to the Supreme Court and challenged that these search and seizures were violating their fundamental rights under Article Clause 1, Clause F, because at that time property was a fundamental right and you could not illegally encroach into somebody's property, because property was also fundamental right under Article 19 and of course under Article 31. But Article 19 Clause 1 Clause F said you had the fundamental right to acquire, dispose or any such to the property, right? And also this was a violation of Article 20 Clause 3, which basically gave you the right to self-incrimination, that you were forcing evidences against the people without their consent. Okay. Now in this case, there were 8 judges in the Supreme Court. You don't have to remember any of this. Just that there were 8 judges in the Supreme Court who said that, boss, the makers of the Constitution did not intend to put it in the Constitution, and that is why it's not in the Constitution. The makers of the Constitution did not intend to put search and seizure provisions in the Constitution. So therefore, it's not in the Constitution. What 1 or 2 members said does not matter. It is not in the Constitution, so it's not in the Constitution. So we are going to go by the mind of the makers of the Constitution by reading through the Constituent Assembly debates. And Supreme Court gave its judgment on the basis of the recorded debates in the Constituent Assembly. And therefore, the search and seizure as a violation of privacy was not even a question. They said that, like how the US Constitution has the 4th Amendment against unlawful seizure, that our Constitution does not do that, and there is absolutely no need to import such an idea when you already have additional laws and so far as it is concerned, and it would be a very strained construction on the Constitution. So basically, MP Sharma versus Satish Chandra, right to privacy is not a fundamental right per se, and 2, search and seizures are not an element of right to privacy in the first place. Now, Kharak Singh versus State of UP. A beautiful case, very interesting case. So what had basically happened was, Kharak Singh was arrested for dacoity, but was later released because of the lack of evidence. Now, the Uttar Pradesh police bought Kharak Singh under surveillance. Now, what kind of surveillance will there be in 1962? You will go to Kharak Singh's house, keep a check on what he's up to, follow him, this, that, the other. And the UP police had the powers of conducting such a surveillance under the UP police regulations, chapter 20. Again, irrelevant, just showing off my technical knowledge. Okay. Now, what they started to do was that they started unreasonably at 11 o'clock, 12 o'clock, come to his house, wake him up, follow him around unreasonably. So Kharak Singh, a dacoit, allegedly charged with dacoity, went to the court and challenged that these UP police rules are violating my freedom of movement and right to life and liberty. My privacy is being violated. And that is why the 6-bench judge of the Supreme Court said that no doubt these late night visits at night are unconstitutional. You can't disturb somebody at 1 o'clock at night, at 10 o'clock, 11 o'clock at night. You can't do that. But upheld the rest of the regulations. That's okay, but this is crossing a line. But it is also very important that the judgment very clearly said right to privacy is not a part of the Constitution. Right to privacy is not a guaranteed right in the Constitution. So we had a very conservative and a very restrictive approach as far as right to privacy was concerned. Okay. Then in 1975, in this Govind versus Madhya Pradesh case, basically again, Madhya Pradesh police regulations were also relating to surveillance, including domiciliary visits, very similar to Kharak Singh, right? Now, the problem was that Govind also was somebody who was being surveyed upon because of a notorious past. Govind Singh alleged that these are false allegations, and under false allegations, you are doing this. Right. Now, you must understand that the Supreme Court dismissed the petition but cautioned the Madhya Pradesh police that, you are just on the edge of unconstitutionality. So, be careful. Okay. Now, it is the 2017 judgment, that is almost after, 25, 35, 37 years, that we came back to this, where a 9-judge bench of the Supreme Court in 2017 delivered a unanimous verdict, which means all the 9 judges said the same thing. And this was essentially in Puttu, Swami and connected matters, in which they said the Constitution of India guarantees each individual a right of privacy, and that is an implied right under Article 21. Do we understand this? Is that okay? Is that fine? Clear? Now, if you want to understand this, please understand why was this the case, what was the problem, and so on and so forth. Now, this case that we are referring to, right? This case that we are referring to has been decided and has been closed in 2017. This case was essentially overruling MP Sharma and Kharak Singh, and of course then was looking at whether right to privacy is a fundamental right or not. Clear? Understood this? Are we fine with this? Yes. Okay. All right. For UPSC, just know 48, 62 and 17, and that is more than enough. Right? Now, in your notes, though this is not just a part of your polity syllabus, but I have just given you some additional information on the IT rules and the arguments around it. So please read those. I will not be discussing them in class because they are not needed. As long as you understand what we have broadly spoken about, that is more than enough. I don't need you to worry about it. Basically, in the notes, I will show you what I have done. Right. So I've given you some larger analysis here with respect to debates around the IT Act on the originator issue. So I've given you some points here. You can read them. I've discussed them broadly in class. All right. These are things that you can use in your GS paper 3 and ethics answers also. That the larger discussion is that who do we give more power to, the government or companies, and is that the only solution? How do we create fair and equitable systems? Then of course I've explained to you why private companies have a problem with this. Then of course the features of these rules, we've discussed this already yesterday in terms of OTT censorship and originator content, how social media often gets misused. I've given you some data sets also on how India has the largest WhatsApp user base, and with about 340 million, and several further other populations are dependent on it, which is why it's very important to keep a check on the kind of information that gets disseminated. A lot of times morphed images of women, communally sensitive videos, deep fakes, all of those things can happen, which is why we need a better technological law. And then of course, what are the issues? The companies say that if we give you the originator identity, then we are violating end-to-end description. The government is saying that your end-to-end encryption is still not going to be violated if somebody who is committing a crime, their identity has to be disclosed. Then the companies say that we don't have the technology for it. Then the government says, then build technology for it. That is your job. 20 years ago, nobody had heard of WhatsApp. Today, WhatsApp is the part and parcel of our life. Businesses and districts and governments run on WhatsApp today, right? Yes, so these are some things that we have to be careful of. Twitter is saying that if you ask us to do this, then we'll kill free speech. Twitter, of course, has filed a case in the Delhi High Court. I've given you all of this. Then as an extension, I've also given you certain write-ups on the right to internet. Basically, two judgments. One, that your right to internet is a negative right, which means that the government cannot stop you from accessing the internet unless there is a reasonable reason to. But this does not mean that the government is going to provide you with free internet. That is not what the right to internet means. Right to internet as of today means that unless it's reasonable, the government should not stop you from accessing your internet. And as far as the Puttu Swami case is concerned, they've given you the guidelines of proportionality. What can be the reasonable restrictions of restricting internet access? They, for example, should be for a legitimate reason, and the reason and how you're going about it should be correlated. The measures should be fair. The restrictions must only be for reasonable, legitimate purposes, and of course this entire process should have procedural safeguards. This also means that in the High Court, though the Kerala High Court has said that right to internet is a part and parcel of today's society, but we don't have a positive right to internet at the time. We only have a negative right to internet, which means that the government is not going to put a tower in your house just because there is a right to internet. It just means that the government should not unreasonably restrict your internet. However, throughout the world, everybody understands that today technology is not just an enabler of, it's not just a right, it's also an enabler of rights. It's because of technology that freedom of speech and all of those also depend. And General Assembly and United Nations Human Rights Council, all of them have said there is an importance of internet. But we are very clear on our conclusion that I understand technology is an enabler of rights. But I am not, as the government, going to provide you with free internet. That is Reliance's job, but don't worry, Reliance and us are more or less the same thing. So don't worry about it. We are not going to give you the infrastructure for it, but we should not unreasonably restrict your internet, and that is okay, and that is fine. And then, of course, I've given you the broad structure for way forward, which could collectively be used in 19 and 21 as well, right? As I was discussing in the Navteej Singh Johar case, that now homosexuality is decriminalized, which basically means that I'll come to LGBTQ and I'll run you through this. Okay, so we are clear with this. Now, LGBTQIA, and I just want to run you through some of this. You don't really get questions on this, but I think this is very important. And please understand this as clearly and as carefully as you can. Right. So let's talk about this. Let's understand what is it that we are referring to. LGBTQIA, and I'll give you the terms behind it, are essentially issues of identification. And identification has two components. One is sexuality and the other is gender. Now, please understand, both of them mean very, very different things. Sexuality means the choice and the preference of partners and personal sexual expression. Both are two very different things. Who is your personal, your preferential intimacy choice? And how do you express your intimacy are two ingredients of sexuality, right? And it is not just about, how you are outwardly going about it. It also has very simple explanations of how you dress, how you style yourself, and so on and so forth. Gender, on the other hand, is often the most misunderstood. Gender is a classification on biological components, that if you have male components, you are a male, you have female components, you're a female. But then we've added a social construct to it, that males who have male, you're a male because you have a male organ, and you're a female if you have a female organ. But as a male, you are supposed to be doing X number of things. As a female, you're supposed to be doing Y number of things, right? Now, both of those don't necessarily overlap. Just because you're a male, you're not supposed to do masculine things. And just because you're a female, you're not supposed to do feminine things. Unfortunately, we have built industries, ideologies around these toxic notions of masculinity and femininity. For example, men are supposed to be rugged, adventurous, outward, and women are supposed to be shy, coy, dignified, graceful. These are all personality traits that we've unfortunately attached to gender, which is why you will see that if a girl is into adventure sports, then she is considered a tomboy. And if a boy likes cooking or knitting, then the boy is considered to be feminine or effeminate. These are social constructions, and we've built industries around it. The fairness cream industry is a multi-billion-dollar industry. The cosmetics industry is built on how women are supposed to look beautiful. Men, not so much. Today, of course, the beauty industry is extended to men also. So you have notions of metrosexuality and stuff like that. But that's largely how it is. Similarly, for example, if you see a Coca-Cola, a Thumbs Up ad, a Mountain Dew ad, it's adventurous. It's always a man who's climbing up mountains and jumping off roofs. Similarly, you'll see a lot of these financial advertisements, that LIC ad or an investment ad, where the female is the wife carrying around, stuff at home, and the man is the worker, and the man is thinking what I can do to provide for my family. The very notion that men are supposed to be providers and women are supposed to be enablers and support systems is in fact a gender construct that we've created, a gender construct that today exists and which is the fundamental cause of almost everything. right? And that is something we must understand, and that is something that we must thoroughly imbibe in what we are, and we must look beyond this. So LGBTQIA is essentially going beyond this. So when we look at the elements of LGBTQIA, what is it that we are referring to? What is it that we must get right? So for example, gay and lesbian means, this is one of the most basic classifications. It's based on same-sex attraction. Bisexual means if you're assuming there are two genders, then you're attracted to both genders. Pansexual means if you're assuming there are more than two genders, then you're attracted to all gender identities. Asexual is somebody who has no sexual urges. Intersex is somebody who has a combination of biological characteristics. It could include chromosomes, gonads, sex hormones, or even genitals. Transgenders, and please understand this, is not a biological trait. It's a psychological identification. A person may be biologically male, but identifies as a female, and therefore wants to convert the biological characteristics to a female. That is okay. Like for example, there's a movie recently on transgender by Ayushmann Khurrana and I think Chandigarh Ashiki or something. It's on Netflix. It's about this issue only, right? So transgenders is who you identify yourself to be. Then the next step is you could undergo a sex reassignment surgery. And then somebody who does not conform to any gender identity is somebody who's non-binary in nature, right? Now, several countries have had several laws, Netherlands, Mexico, US, they all allow, same-sex relations. Most of the South Asian, Central Asian, Islamic belt does not really allow it because Sharia law is largely conservative in nature. And I hope you understand what Sharia law is. Sharia law is dependent on two basic interpretations, Shia and Sunni. And there are 5 schools of thought, 4 of which will probably belong to the Shia and 1 will belong to the Sunni. And Sharia law is a combination of the Quran, the Hadith, and other elements which could serve as interpretations of Islam, right? So that's something you should know. Anyways, historically, when you look at LGBTQ, we understand that again, most of this in LGBTQ that has happened in India has been largely because of the Supreme Court. But historically, we've seen, kinnars or hijras as a part of ancient text. Even in the Mughal rule, that was also, they were given equal status in the court or in the courtyards or all of that. This essentially became a problem with the advent of the British rule, where we came up with the British law which said Section 377 is where homosexuality is going to be illegal. Now you must understand the word homosexuality is not defined anywhere in the Constitution. It is unnatural sex, which is. And through Supreme Court judgment, it has been derived that unnatural sex could also mean homosexuality. So what has basically happened in the Navtej Singh Johar case, the 2018 case, the Supreme Court has basically said that 2 consenting adults in their private space can of the same gender be physically intimate. Unnatural sex today will not mean homosexuality. Okay, other forms such as anal sex or perhaps oral sex, that could still in fact be illegal. But homosexuality or 2 people of the same gender who are physically intimate with each other in their private space is perfectly legal. In the public space, any gender cannot be physically intimate because that is by Indian law outraging public modesty or breaching, public morality. Okay. Now, as far as legislation is concerned, as I said, Navtej Singh Johar has been able to give rights to homosexuals. Similarly, in 2014, NALSA, the National Legal Services Authority, had recognized that transgenders are the 3rd official gender and they should be given the OBC status and asked the parliament to make a law on it. The parliament did make a law on transgenders but did not give them OBC status in it. Okay, so transgenders are legally today recognized as the 3rd gender. Okay, whether you fill a form in the government or anything, transgenders are recognized. And there have been, you can pick up several examples from the newspapers throughout the next year where you will see professors, university vice chancellors, heads of departments, several states have started recruiting transgenders into their police forces. A lot of those things have to happen. and all of those things, right? These are very sensitive topics. I hope you understand that they've been pushed to the point of poverty, that they have to, resort to begging on the streets. It's because we have, societally and systematically for years and years and years denied them equality of status and access. So that's something that has happened. I've given you a review of the transgender law. It's very simple, that you can't discriminate against them. You have to create a national council for transgender persons. This is not going to be a constitutional body, but a statutory body. Recommendations that you should also make it a constitutional body. And the law still does not provide for OBC reservation to transgenders. I've given you these. And the problem, of course, lies with identification. It's a psychological identification. If one person feels that they should have been a woman and they're a man, or they should have been a man but they are actually a woman biologically, it is a psychological identification. Now, the DM is going to, of the district, certify on that. The DM is not medically or otherwise equipped to have the kind of expertise in these matters, and that is something that we have to be very clear, right? Okay. Malik Kafur was the chief of the army of Alauddin Khilji. He was a gay. एक तो a gay कुछ नहीं होता है, but I don't know this, Irshad. I don't know of this fact, so I can't verify on this. ठीक है. Now there are the things that we can do to make transgender communities better. Of course, some symbolic, some better initiatives, and so on and so forth. This is what transgenders and homosexuality is. Today there is a petition which is currently pending in the Supreme Court, where the same set of petitioners, the same set of lawyers are arguing that homosexuals should also be allowed to legally marry in the country, so that they can adopt, they can jointly acquire property and have a common financial status, right? So this is more than enough. You do not need anything else as far as your theme 3 is concerned. Okay. Now, apart from this, there's a very small issue called Uniform Civil Code left. This Uniform Civil Code, I'm going to issue a handout, and I'm going to discuss this in the larger context of vulnerable sections also later on. But I'm going to close theme number 3. This is enough information. You don't need anything else as far as your theme number 3 is concerned. To broadly tell you, Uniform Civil Code is nothing but creating a law which takes its Uniform Civil Code does not mean a, let me explain this to you clearly. Uniform Civil Code does not mean a single law, a single law to be applicable to all religions. Yes, Jayaprakash Jha, right to be left alone kuch nahi hai. We have the right to be forgotten. There have been several Supreme Court judgments where you have the right to erase your identity and the courts must comply with that, right? I've given you a note on it. Of course there is. Okay. Now, so we must understand that in India, we have a bunch of laws taking into account certain religious practices, and we have separate laws for separate religions, and they largely govern marriage and divorce and property, which is also called succession. You have the Hindu Marriage Act and the Hindu Succession Act, for example, which applies to Hindus, Buddhists, Jains, and Sikhs. Then you have the Muslim Marriage Act, you've got the Christian Marriage Act, and then you've got the Special Marriage Act. Now, each of these have their own provisions, legally recognized provisions with respect to marriage and property. And each of these have had certain issues. Like, for example, it was only in 2005 that the Hindu Succession Act was amended and women got an equal share in property. The lack of intimacy between a husband and the wife is a ground for divorce, which is an issue given the fact that most marriages in India are arranged marriages. The Muslim Marriage Act all of this says that if a girl attains puberty, she can get married. So even if she attains puberty at 16, that could still be considered as a valid marriage, which is why when you're looking at improving the age from 18 to 21 through the Prevention of Child Marriage Act, it should hopefully overrule the Muslim Marriage Act. Similarly, there are problems with the Christian Marriage Act in terms of, abortion. And then the Special Marriage Act covers inter-religion and inter-caste marriages. Right? Now, what we are basically trying to say is that have a uniform civil code which is in your directive principles, which say that which basically say that Muhammad, that is ceremonial, it's not legally recognized. Now, in the Uniform Civil Code, we are basically saying we are going to have one law. Let us say that law has sections 1 to 5, 6 to 10, 11 to 15, and 15 to 20. This will cover Hindus, Buddhists, Jain, Sikhs. This will cover Muslims, this will cover Christians, and this will cover inter-religion. And this will cover everything to do with marriage and divorce and property and adoption. Like how we integrated factory laws into labor codes, this is like creating a uniform civil code on all of these personal laws, right? Now, people are of course worried that this is going to violate the secular structure. Right now, we don't have a national uniform civil code. The only state that has a uniform civil code is Goa. And like, for example, all marriages have to be compulsorily registered. Everybody gets equal share in property in Goa, irrespective of the religion. But it also has some problematic areas. Like, for example, in Goa, Hindu men can have 2 wives. That's a problem with the Goa Uniform Civil Code. So we're looking at a national uniform civil code so that it will be nationally applicable. Yes, states can have their own civil code. That's not a problem. But if you have a national civil code, that will give you a uniform structure to this, right? There have been 2 basic cases which have prompted to why this should happen. The first case was the Shahabano case, wherein the court directed her husband to pay her an increased alimony and said we should have a uniform civil code. That led to a lot of protests in India. And the second case is the Shaira Bano case, where the court declared triple talaq to be unconstitutional and directed the parliament to make a law to criminalize it, right? Necessitating that there should be a common law for all of this. So this is why this has largely been in the news. The reason UPSC asked a uniform civil code was that is the year Shaira Bano was effectively in the news. Okay, so this is the case. I'll give you a handout on it. This is more than enough. Please do not do anything else beyond this for fundamental rights. Nobody is going to ask you anything more than that. Read the handouts on theme 1. The printable versions will be uploaded within 2 hours. I've already converted them into black-white formats, so you should not have a problem, right? And this should take care of it from most perspectives. Okay? All right? Clear? Okay. चलिए, थैंक यू.